This program is not intended to replace professional legal advice or representation. If you have a legal concern, you are strongly encouraged to seek the advice of an attorney.
Hi, I'm Yanique Otto, attorney at law in South Florida with the Otto Law Group. Thanks for joining us for this episode of Now You Know the Law. So, you're in a car accident, your car is pretty banged up, and you're feeling some pain as a result of the accident. You want to get your car fixed, and you also know that you need medical treatment, but you're broke, and you don't want to get stuck with the bills. You remember hearing somewhere that Florida is a no-fault state, and so you're thinking to yourself, although the other driver is at fault, it doesn't make sense for me to file a claim because since we're in a no-fault state, everyone has to pay for their own car repairs and doctor's bills anyway. Well, here's what you need to know. Yes, it is true that Florida is a so-called no-fault state when it comes to car insurance. Florida drivers are required to carry personal injury protection, also known as PIP or PIP, that covers drivers, passengers, and pedestrians regardless of who is at fault in an accident. This applies to anyone who lives here in the state at least 90 days per year and to anyone who owns a vehicle registered in the state. Now you're required to carry $10,000 in PIP and $10,000 in property damage liability. But keep in mind that Floridians' no-fault insurance does not apply to property damage. PIP insurance covers the bodily injury in a car accident. I call it the health insurance part of your car insurance, if you will. It covers damages such as medical bills, lost wages, and other similar expenses. PIP will pay 80% of your medical bills up to $10,000, but you may still have some responsibility for out-of-pocket expenses such as the other 20% not covered by PIP, your PIP deductible, which could range between $1,000 and $2,000 if you have one, and any medical bills that are over and above when your PIP maxes out at $10,000. At this point, your health insurance should kick in to pay the remainder. If you make a claim against the at-fault driver and recover a settlement or a jury verdict at trial, then your health insurance company may have a right of subrogation or a right to reimbursement to be paid out of the settlement or the verdict. Now, if you don't have health insurance and the accident was not your fault, then you have a right to recover the medical costs over and above that paid by your PIP insurance from the at-fault driver. But it's not an overnight process. It can take a while, and in the meantime, you're still responsible for paying those bills. So here's the bottom line. Yes, we're in a no-fault state, but that does not mean that the person who is responsible for your car accident won't have to pay for the repair to your car, as well as your medical costs which exceed your PIP benefits. If you've been involved in a car accident, give us a call. We can help you protect your legal rights. Thanks for joining us. We'll see you next time. I'm Yanique Otto, and Now You Know the Law.
Now You Know the Law is brought to you by the Otto Law Group. If you have a legal question, give us a call. We'll either help you with the matter or put you in touch with someone who can. To have your questions answered in one of our episodes, you may submit them via our Facebook page at facebook.com/Otto Law Group. The Otto Law Group, providing legal solutions.